All right, good morning, everyone. Hope everyone's doing well this morning.
Good morning, Jarrett.
Your Honor,
Yes, good morning.
I'd like to just open up and apologize. I was having some computer glitches this morning. Luckily enough, I had sent out the announcement to Mr. Walker last night, and I was able to kind of doctor it up and send it out. But I did send an update that you should be using that says good morning. The only update was I had good evening, Mr. Walker, but this one just says good morning to everybody. So everybody knew that this was the announcement for today. So I apologize about that.
Okay, that's not a problem, Mr. Ford.
Everything is the same, and it's okay if I just like to thank Mr. Walker for there was some late add-ons that he was able to at about 10 o'clock last night get me some offers so we could actually see those individuals. And I'd like to thank my two partners, Mr. Feinlein and Mr. McClain, because there was a lockdown at the jail yesterday, and which kind of made us stay out late, and we finished everything, and so I really appreciate their time and effort.
All right, very good. Where are we starting today?
Good morning, Judge. We're going to be starting with position number 3, Mr. Anderson.
Okay, good morning, Francois. Mr. Anderson, let's see, and that's going to be a non-negotiated plea. The NOLO's at issue?
That's the only thing, Your Honor. NOLO is that issue. We feel that my client qualifies for NOLO, but everything else we do agree with.
All right, good morning, Mr. Anderson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Let me start with, who do we have on from pretrial? Ms. Bostic?
Ms. Bostic.
Yes,
I'm
good
pulling it up
morning.
now, Judge.
Okay, while we're waiting on the history, good morning, Ms. Sellery.
Good morning, Your Honor.
You can proceed.
Yes, Your Honor. This incident took place at 2640 Metropolitan Parkway. Police responded regarding a dispute, and the victim, whose name is Kawanica, that's Kawanica, last name Spencer. She informed the officers that she was outside standing next to a building, and she was arguing with another female when the defendant punched her in the face, and then he ran off. The defendant and the victim have 7 children together. Your Honor, I can give you the history regarding this defendant. He has a 2002 simple battery family violence guilty conviction. That's against the same victim. He has 2 probation violations after that. In 2008, he has a guilty conviction for battery family violence, the same victim. And then he went on to violate probation twice after that. Another battery family violence, fleeing, driving while without a valid license. That's a guilty conviction. A 2020 simple battery family violence guilty conviction. In 2021, ag assault strangulation guilty conviction. All of those batteries are against the same victim, Your Honor. So the state does object to a NOLO plea in this case. The offer is 12 months to serve 90 days, credit for time served 19 days, the balance probated. In FBIB, no contact with the victim and stay away, nothing further.
Okay. Mr. Ford, based on his history, I would not allow him to use a NOLO, based on the history alone.
Just the history, Your Honor, because he has not used a NOLO in 5 years, Your Honor.
No, I'm not going to allow him to use a NOLO.
Okay, all right. We'll proceed, Your Honor.
Okay. Go ahead, Mr. Ford.
Your Honor, like I said, if we have no issues with anything, so at this point, we concur with the state's recommendation and we waive the factual basis, genuine ID.
Okay. Mr. Anderson, it's my understanding that in case 22 CR 002613Y, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Anderson, I'm going to waive your probation fees for you while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire 12 months, okay?
Yes, sir. Can that be non-reporting once he, Your Honor, can that be non-reporting after he completes his condition?
I want him to stay on probation the entire time, given his extensive history, Mr. Ford, but I will waive the fees for him.
All right.
Your Honor, I apologize. The jail time was not correct. That was for a different defendant. His jail time is 209 days, credit for time served 209 days.
Okay, thank you, Ms. Sorry. All right, good luck to you, Mr. Anderson.
Okay, you too. Thank you, sir.
You're welcome.
I ain't gonna sign that. No. All right, thank you.
Position 5, Brown.
Good morning, Mr. Brown. I'm Judge Jarrett Morrow. This is the state court all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Yes, sir. Yes, sir, I do.
Thank you. Can you raise your right hand for me, Mr. Brown? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Does he have any prior shopliftings?
Yes, yes, Your Honor. He has three, I'm sorry, guilty convictions for a theft by shoplifting, one at the same incident location.
All right. Go ahead, Ms. Sari.
Yes, Your Honor. This incident took place at the Texaco gas station located at 3 Joseph E. Lowry Boulevard in Atlanta. The defendant walked into the store and took 2 12-pack cases of beer. Again, there are 3 theft by shoplifting guilty convictions. This case really should be a felony. However, we're offering 12 months to serve 28 days, credit for time served 28 days. The balance probated, anti-theft course, and to stay away from the incident location.
Okay. Mr. Ford?
Thank you, Your Honor. As been mentioned by the solicitors, that my client has just pled on November 10th to 3 theft by taking, Your Honor. We're asking that he be given a NOLO because he has not used his NOLO plea, and also that the anti-theft class be waived due to the fact that he's taking anti-theft class on the other guilty convictions that he has. He's really not working. He tries to work for a staffing agency, Your Honor. We're also asking that his fees be waived, and once if there's any conditions, once he completes the conditions, that his probation be terminated.
All right, I'm not going to allow him to use a NOLO. If he has an anti-theft class that he's already been, already has to have, I would imagine that they're going to, if he takes an anti-theft class, it will count for this case. So I am going to require him to take the anti-theft class. I am going to waive the fees, and it'll go to a non-reporting status once he's completed the class.
Are you okay with that? All right, we can continue, Your Honor.
Okay. Mr. Brown, it's my understanding that in case 22 CR 007693E, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea, Mr. Brown. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And as soon as you complete the anti-theft class, it'll go to a non-reporting status, okay?
All right, thank y'all.
You're welcome. Good luck to you, Mr. Brown.
All right, good luck, Mr. Brown.
Position 6 through 9, Mr. Brownlee.
And who's representing, is Mr. Pugh on the line? It does not, it doesn't appear that his attorney's on the line as of yet.
We're going to come back to your case, okay, Mr. Brown? Position 18, House.
That's you.
And this is going to be a non-negotiated plea, is that correct?
Morning, Judge. Zach Finley. And yes, that's correct, Judge. This is a non-negotiated plea with a jail time at issue.
Good morning, Mr. Finley. Good to see you.
Morning, Judge. Good to see you.
Good morning, Mr. Howes. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Good morning, Ms. King.
Good morning, Your Honor. How are you doing?
I'm doing well, thank you.
The state offers 12 months to serve, 60 days, credit for time served, 15 days with the balance probated, a sexual deviancy class, no further contact, a stay away, no drugs, alcohol, or weapons. The state is asking for an additional 30 days to serve. On November 7th of this year, officers responded to 38 Peachtree Center, which is Langdale Hall on the Georgia State campus. Upon arrival, they met with the victim in this case, Mahtab Hasmer, Mahtab, last name Parsamehr. And she stated that an unknown male, and she described what he was wearing and a description, approached her from behind and grabbed her butt. She said she was walking on Decatur Street in Kimball Way on the Georgia State campus when this attack occurred. After that, the defendant ran away because she started to scream. Officers noted that when they approached her, she was very frightened. She almost couldn't speak because she was so traumatized by what happened, but she did state that she wanted to press charges. She completed a statement form on that day. Your Honor, the state is requesting time because he has a public indecency conviction from this year, Your Honor. He is still on probation for that incident. In that incident, it was actually near the same location, and he exposed his genitals to another young lady in that area, Your Honor. We feel like he's a danger to society, and for that reason, he should serve the additional 30 days.
When was that plea entered? Do you know, Ms. King? And
It was last month, Your Honor.
And was there anything associated with that as far as classes or anything of that nature?
Let me look right now. I have it pulled up. He is to probation, MH. There is an MH in there. No firearms. I do not see anything about a class, Your Honor.
Okay. Okay, thank you. Mr. Finley?
Yes, Judge. And as previously stated, jail time is an issue. I know it stated that he would have 30 more days, but after the 2-for-1, it would just be 15 days that he would have left. He's already served 15 days. The judge, I am asking for it to be time served, Your Honor. Mr. Howes is taking responsibility for his actions, but I am hoping, and he is hoping, that he can get out and be with his family for Thanksgiving. He has 3 kids, all of which he would be spending Thanksgiving with. It would be held at his grandmother's house, who recently beat cancer and is turning 81 this month. He has been working at J&J Pallets and will work there once he gets out, Judge. But once again, Mr. Howes is taking responsibility. He has served already 15 days, and I'm not sure what 15 more days is going to accomplish that the 15 days he already served in time. And he is completely understanding and will take the class and understands the no further contact and stay away and will abide by those. So once again, judges, I'm asking for the time served.
Mr. Phelan, if he had a clean record, I would certainly go along with your recommendation in the case, but since he doesn't, and since it's something that's of the same nature, I don't feel comfortable. I believe that that the recommendation from the state is adequate for the charge. So I will be imposing that sentence if he wants to enter a guilty plea to this charge.
Okay, all right, we'll move forward, Judge.
All right. Mr. Howes, it's my understanding that in case 22 CR 007683C, you wish to plead guilty to one misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. House. The sentence is going to be 12 months to serve 60 days, credit for time served 15 days, the balance probated, SD class, and no further contact, and a stay away from the incident location, no drugs, alcohol, weapons while out. While on probation. I am going to waive the probation fees for you to help you get and stay on your feet, but you're going to have to be on probation for the entire 12 months. All right, good luck to you, Mr. House.
Thank you.
Positions 27 and 28, Mclarity.
And it's my understanding that these would be negotiated pleas. Is that correct?
That's correct, Judge.
Good morning, Mr. McClarity. I'm Judge Jarrett. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Morning, yes, sir.
Thank you, Mr. McClarity. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. King?
Thank you, Your Honor. The offer is 12 months to serve 210 days, credit for time served 105 days with the balance suspended. No further contact and a stay away. No further contact with Willie Carson, Willie, last name Carson, and a stay away from 410 Temple Street Northwest, apartment 7.
And position 27 is going to be null prost?
That is correct, Your Honor.
And I have Ms. Lewis in court with me today, so if you all would get all that paperwork to her, we'd appreciate it.
Yes.
Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which we do accept and do stipulate to the factual basis, then you and I do.
Okay. Mr. McClarity, it's my understanding that in case 21 CR 000244Y, you wish to plead guilty to battery substantial physical harm. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Is anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. McClarity. Good luck to you, sir.
Thank you, sir.
Position 21, Mr. Johnson.
It's 410 Temple Street. Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Who's presenting for the state?
I'm sorry, Judge. What position is this?
Position 21, Joshua Johnson.
Second.
The offer is 12 months to serve, 34 days, credit for time served, 17 days with the balance suspended, no further contact, and a stay away. The stay away address is 5444 Key Haven Place. That is the Waiver Park subdivision. And that's no further contact with Tallian Lay, Talliann, last name Lay.
Mr. Finley?
Yes, Judge, that is our understanding of the offer, of the time served offer, and we have accepted that. When we do stipulate the factual basis, venue and ID, Judge.
All right. Mr. Johnson, it's my understanding that in case 18 CR 003592E, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Johnson. Good luck to you, sir.
Appreciate it.
Position 23, Jones.
And this is also a negotiated plea.
That's correct, Judge.
Ms. King?
Yes, Your Honor, the offer is 12 months to serve, 26 days, credit for time served, 13 days with the balance suspended, and a stay away. The stay away address is the Motel 6 at 1377 Virginia Avenue.
Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which we do agree and stipulate the factual basis, ID and venue, Judge.
Mr. Jones, it's my understanding that in case 22 CR 007749C, that you wish to plead guilty to willful obstruction of law enforcement officers and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Jones. Good luck to you, sir.
Position 25, Lawton.
Also a negotiated plea.
You know, Judge, this is actually going to be non-negotiated, but just asking for the balance suspended instead of balance probated.
No objection from the state, Your Honor.
Okay, so he's not going to be required to have a deaf class?
I think you're on mute.
Oh, my apologies. Due to the age of the case and also due to the defendant not getting in trouble after this incident, the state will be amenable to amending the theft class and suspending the probation.
Okay, just wanted to make sure. Thank you, Ms. King. You can go ahead. So it's negotiated at this point.
Yes,
That's
sir.
correct, Your Honor. The
All right.
offer is 12 months to serve, 26 days, credit for time served, 13 days with the balance suspended.
And
Mr.
that's,
Finley?
yes, yes, Judge, that is our understanding of the offer, of which we do agree.
Mr. Lawton, it's my understanding that in case 20 CR 000299A, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes,
Are you under the influence of any drugs or alcohol this morning?
no, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am, sir.
You understand that you have a right to a trial by jury on this charge, and if by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Lawton. Good luck to you, sir.
Thank you, sir.
You're welcome.
Position 20, Mr. Jarrett.
This is going to be an arraignment.
Yes, Judge, it's gonna be arraignment and address bond, Your Honor.
Okay. If I can get that bond when you get a moment. Good morning, Mr. Jarrett. I am Judge Eric Morrow. Whenever you're ready. You ready? Okay. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Jarrett. You have been charged in case 15 CR 0013339Y with simple battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead, Mr. Jarrett? Guilty or not guilty? We will record your not guilty plea. Your case will be returned to the division judge and you will get notification of your next hearing date. Yes.
This case was arraigned back on October 21st, 2021, which was set for Jarrett. It was a bond forfeiture case before Judge Edie asked him for a cash bond with the bond forfeiture on. So I think before we went, it's a bond forfeiture case.
Okay. Given the age of the case, Mr. Finley, what was the issue? Apparently, it's a bond forfeiture case with Judge Edie. What was the problem?
Yes, Judge. And I did meet with Mr. Jarrett for a while yesterday, and I explained to him that obviously this is also there's a time served offer with no probation. But I repeatedly went over that with Mr. Jarrett, and he adamantly wants to plead not guilty and.
Oh, no, I don't have an issue with him pleading not guilty,
Yeah, no, he wants
Mr.
to-
Finley. I just want to know why he didn't, why he was, I mean, he wouldn't be here today if he hadn't missed a court date at some point in time. And you know that I don't normally address these type of issues, but given the age of the case and where we are as far as what this week means to people, I'm willing to hear it in this case. So.
Yes, Judge, he did want to have a signature bond, and I was going to ask for a signature bond, Your Honor. He could be living with this aunt moving forward. I do have an address for him, and he plans on working once he gets out, and just wanted to be with his family.
First, still stabbing on Auburn Avenue. That's where I work at, sir.
And so yes, Your Honor, he wanted me to ask, and I wanted to ask for a signature bond on Mr. Jarrett's behalf. And I do understand, obviously, that he's.
Okay.
Your Honor, the state would like to be heard on this matter.
Yes, Ms. King.
So the defendant has a 2020 conviction for shoplifting and false name. He also has a simple battery conviction subsequent to this offense before, Your Honor, from 2017, as well as an obstruction conviction from 2018. He also has 3 disorderly conduct convictions from 2017, a felony marijuana from 2013. He also has multiple felony convictions from 2013, from which he is still on probation for, Your Honor. So while this defendant would like the benefit of the signature bond again, he has abused the privilege that he received of the signature bond before by violating Georgia law again and even being convicted of multiple offenses since this case before, Your Honor, where he did receive a signature bond. For that reason, the state asks that it remain as set.
Okay.
All his notices came back.
Say it again.
All his notices came back because it says homeless home. All his notices came back. There's no good address on none of these.
All right, so apparently what's going on is that Mr. Jarrett has not updated his address and all of his notices have been returned to the court. He was initially given a signature bond of $15,000 back in 2015. Back in 2016, he was, I guess, subsequently arrested and given a signature bond on this case for $3,000 through the jail. Given Mr. Finley, given that he's been given a number of opportunities in this matter, I'm reticent to give him another one. I think that at some point that we're going to have to deal with this, but I don't believe that giving him a signature bond's in anyone's best interest at this time.
All right. So, Your Honor, I know Mr. Jarrett wants to reconsider a plea. Should we do that today, or should we do that another?
I'm here till the end of the calendar, Mr. Finley, so if you all want to discuss it and get back with me by the end of the calendar, I'm happy to take that plea if he wishes to do so.
Okay, that sounds good, Judge. I will speak with him later on the calendar.
Okay, all right, thank you. All right, we'll be back with you, Mr. Jackson, possibly.
Position 31, Meadows.
There's also a position for, people on the gallery.
Okay, thank you. Good morning, Mr. Meadows. I'm Judge Eric. Good morning, sir. I'm Judge Eric Moore. This is a state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
All right, thank you, sir. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, let's see. Okay, 30 and 31. All right. Yes, you can put your hand down. Thank you, sir. Ms. King?
Yes, the offer is 12 months to serve 34 days, credit for time served 17 days with the balance suspended, no further contact and a stay away. Position 31 will be dismissed. The stay away is from 60 Cleveland Avenue in Atlanta and no further contact with Curtis Barber, Kurtis, last name traditional spelling.
Mr. Finley?
I just want to make sure that was balance suspended, correct?
Yes.
Okay.
Yes, that's correct.
Yes, Judge, that was our understanding of the offer, of which we do agree and do speak with the actual basis. Can I do, Judge?
Okay. Mr. Meadows, it's my understanding that in case 21 CR 004103J, you wish to plead guilty to false report of a crime. Is that correct?
That's correct, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury and that by pleading guilty, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Meadows. Good luck to you, sir.
Thank you so much, Your Honor.
You're welcome.
Position 33, Palmer.
Good morning, Mr. Palmer. I am Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you put your hand down, Mr. Palmer. Thank you. Ms. King?
Offer is 12 months to serve 32 days, credit for time served 16 days with the balance suspended, no further contact and a stay away. Then that's no further contact with Jason Kroenemeyer, first name traditional spelling, last name Kroonemeyer, and the stay away is from 2452 Morosco, Morosgo Way Northeast.
Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which we do agree. We do stipulate the factual basis, ID, and venue, Judge.
Mr. Palmer, it's my understanding that in case 22 CR 007675B, you wish to plead guilty to 2 counts of criminal trespass. Is that correct?
Yes, it is.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Is anyone forced or coerced you to plead guilty?
No, they haven't.
I'll accept the plea as negotiated, Mr. Palmer. Good luck to you, sir.
Thank you.
You're welcome.
Position 10, Mr. Burnett.
Good morning, Mr. Burnett. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Absolutely. Good morning.
Good morning, sir. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you, sir. Ms. Sari?
Yes, Your Honor. In this case, this actually happened at MARTA, located at 1400 Lee Street, Southwest in Atlanta. The victim in this case name is Travis Stevenson. He informed MARTA police that he was punched in the head several times by the defendant, and he did receive injuries regarding this battery. Your Honor, the defendant has a 2020 criminal trespass guilty conviction. He has an open battery in Cobb. That's a battery, criminal trespass, and terroristic threats. And he also was suspended from MARTA due to an obstruction charge that he received. So he's actively suspended, yet he was there on this date. The state's recommendation is 12 months to serve 34 days, credit for time served 17 days, the balance probated, an 8-week anger management course, no contact with the victim, and to comply with MARTA suspensions. Nothing further.
Mr. Ford?
Thank you, Your Honor. We do concur with the state's recommendation. Other than the 8 weeks of anger management, my client is not working at this time and does not have the funds. He feels that he could probably do the 4-week anger management course, not the 8-week course at this time, Your Honor. Like I mentioned, he has not had a NOLO in 5 years at this time, and we're asking that after the sentence that his probation fees be waived, and when he completes the class, that his probation be terminated. He does not know the alleged victim, Your Honor, at this time, so the stay away or no further contact is not an issue.
Okay. If he wants to plead guilty, I'm going to accept the state's recommendation.
Your Honor, my client is prepared to plead guilty at this time, and we do agree with the terms and conditions of the state's recommendation, and we stipulate to the factual basis, venue, and ID.
Thank you, Mr. Ford. Mr. Burnett, it's my understanding that in case 22 CR 007629G, you wish to plead guilty to battery and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept your plea, Mr. Burnett, 12 months to serve 34 days, credit for time served 17 days, balance probated, an 8-week anger management course. No further contact with Mr. Stevenson, abide by any MARTA suspensions. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Absolutely.
All right, good luck to you, Mr. Burnett.
Good luck.
Position 15, Green.
And this is going to be an arraignment.
That's correct, Your Honor.
Good morning, Mr. Green. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Green. You've been charged in case 21 CR 001568G with battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead, Mr. Green? Guilty or not guilty? We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Your Honor, we did ask for a bond hearing on this.
Okay, do we have his bond?
This was a bond over, which was originated on the SAP on April 6th. And it was reset for jail jury further notice.
Okay, while you get that for me, is it,
On the corner to the booking screen, but this was a bond over case.
Okay.
$10,000 bond. Sure.
all right. Let's see, can I get his history, Ms. Bostic?
Judge, I have 4 prior arrests. Let me go back to it. Sorry, Judge. 4 prior arrests, no disposition on all the cases. His last arrest being in 2020 for aggravated battery and battery.
And
His history seemed to be violent cases. The other one is for a simple battery, and the first one is a juvenile arrest for a CWAC case.
all right, thank you. Ms. Sally,
Yes, Your Honor. For that simple battery, it was a simple battery family violence. I have a guilty conviction, and that case number is 19CR010071F as in Frank. And yes, he does have the ag battery that's open. Both of those cases are regarding different victims. In this case, officers met with Rhonda Betting, that's Betton. She stated that the defendant was her boyfriend at the time, and he took her vehicle a week prior without her permission. And on this day that she spoke with officers, she met with the defendant to get her car back, but instead he punched her in the face. She was inside the vehicle with him. He pushed her out, stomped on her face, and then drove off. And he later did wreck the vehicle, Your Honor. The state's
We object, sorry, because at this point, she's describing another case, not this one. So I don't think it has any bearing on this case at all. So I object to her being able to talk about the facts of a different case.
And Your Honor, these facts are regarding this very same case, so I'm not sure what Mr. Ford is referencing. However, the state's recommendation in this case was 12 months to serve, 365 days, credit for time served, 365, the balance suspended, no contact with the victim, and to stay away from her address. Your Honor, due to the defendant's history, the state is requesting that the bond remain as set. Again, he does have a guilty simple battery family violence conviction and that ag battery, nothing further.
Mr. Ford?
Thank you, Your Honor. Yes, Your Honor, there were facts that were similar. He has 2 different cases, but there were somewhat similar facts that Ms. Sari was reading. Your Honor, we're asking for a signature bond. The state was offering Mr. Green time served on this particular balance. Is he okay? With balance suspended, Your Honor, we're asking for a signature bond because my client has done the time that's necessary for this particular case. We don't feel that he should be incarcerated at this time. So we're asking for a signature bond due to the fact that he has served 365 days. He wants to be able to post bond. As you know, this is the Thanksgiving week. He has a $10,000 bond on this. If he gets a signature bond, he feels that he could make the felony bond, which is also $10,000, Your Honor. So we're asking that a signature bond be granted. He's a truck driver for Suncare. He's a high school graduate, Benjamin Hayes, 2 years of college, Your Honor. He's a lifetime resident of Georgia, so he's not a risk of flight. He does have family here, and he does have family support. So at this time, Your Honor, we feel that he should have a signature bond on this particular case due to the fact that 365 days times balance suspended, and allow him an opportunity to make bond on the felony $10,000 bond.
Does he have a place to stay,
Yes.
Mr. Ford?
Yes, he does, Your Honor. I have an address for him.
Okay, you'll have to make sure that hit the address aligns with the address that the court has, so that he doesn't miss any notices if he does get out. Anything further, Ms. Sari?
Yes, Your Honor, regarding the mention of the jail time, this case hasn't been addressed regarding the defendant, even though he has served 365 days. So that's of no bearing on the state. He was reset to he was on an SAP calendar before, Your Honor, back in 2021. So the reason this case is still outstanding, that's regarding the defendant's choosing. So because he has served 365, Your Honor, that does not have any bearing on his bond today. Nothing further.
Okay. Well, I think that if he's been in jail 365 days on this charge, he has a right to come back and defend himself if he wants to plead not guilty to the charge. And I'm going to allow him to do that, especially since the recommendation is a time served recommendation. It's going to be a $20,000 signature bond through the jail. Mr. Ford, please take it down. No further contact with I've got Miss Benton, but Miss Sari, you said Miss Betton. So if we can clarify if it's Benton or Betton, and stay away from her location. No drugs, alcohol, or weapons while out on bond. So, Mr. Green, I'm going to allow you to sign your own bond in regard to this matter, but if you do not show back up for your next court hearing, the bond will be withdrawn.
And Your Honor, it is in the report, it says Betton, Betton.
Okay.
What's that spelling again, Ms. Sari? B-E? I have B-E-N-T-O-N. Can you hear us?
Okay. In the accusation is Betton, so I'm not sure if it's Benton or Betton, but he's to stay away from Miss Rhonda Benton or Miss Rhonda Betton. All right, anything further on Mr. Green?
Nothing further from the state, Your Honor.
Nothing further from the defense, Your Honor.
Good luck to you, sir.
Good luck to you all.
Oh, yeah.
This is going to be on the probation calendar, position 1, Mr. Moss.
Okay. Ms. Harris, are you with me?
Yes, Your Honor. Good morning.
I'm doing well. How are you today?
I'm doing good.
Good, good. Mr. Moss, good morning. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Come on.
Thank you. Good morning. Ms. Harris.
Yes, Your Honor. Mr. Moss was sentenced on probation on December 11, 2018 to 12 months to complete 12-week anger management and 80 hours of community service. As of today, Mr. Moss has never reported to our office, and that's why a warrant was issued. He has 1 month and 8 days remaining on his, 21 days remaining on his case. Probation recommendation is to time serve his case and to close it.
What was that? I didn't understand what the recommendation was, Your Honor.
Time served and close the case.
You agree with that?
And that's time served 3 days? Do we know how long he's been in, Ms. Harris?
I do not.
Yes.
I see he's been in since November 14th, so I think 8 days.
I have
9 days as of today.
Okay, I'm being told 9 days as of today. All right. Mr. Moss, the only reason I'm accepting this recommendation is because you've been in custody for 9 days. This is a 2015 case. You haven't done anything in regards to what the court ordered you to do. So no anger management, no community service. So under normal circumstances, I would not be taking this recommendation. I'd make you stay in custody for longer, given that you have not done anything. But you're sitting there now, back in jail when you could have dispensed with this, 5-6 years ago. So I will accept the probation's recommendation. Good luck to you, sir. Who's next?
Can we do position number 19, 4 North, Eric Jackson?
And this is going to be an arraignment, is that right?
Eric Jackson.
Yes, Mr. Jackson. I'm speaking to your counsel. Hold on a second for me, Mr. Jackson, okay?
All right.
Thank you. Mr. Finley, this is just going to be an arraignment, is that correct?
That's correct, Judge. He is being held.
Good morning, Mr. Jackson. I am Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Mr. Jackson, you've been charged in case 22 CR 007641Y with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do.
How do you plead, Mr. Jackson? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you will get notification of your next hearing date. Good luck to you, sir.
I thought I was here from I'm here for another case.
Mr. Jackson, for the simple battery family violence place that I met with you about this.
Yeah, no, I'm here for the thereby taking and breaking the
He's in
auto.
custody also, Judge, for a felony case.
I
Okay.
don't got a gun.
And he has no bond in that case, Your Honor.
All right, so we don't have that. That's not before this court this morning, Mr. Jackson. That's apparently that's a felony. So you'll have to go before another court to address that case. Okay.
I had went to attorney visit yesterday, and I told them I'm going to court for breaking the auto, and they told me plead not guilty. I ain't know why to plead not guilty for simple assault.
Okay, well that's not this case. The only case that I have for this court this morning, Mr. Jackson, was that simple battery case. Okay, so you'll be getting another court hearing date for any other charges that you have. All right.
All right.
All right. Thank you. Who do we have next?
Position 41, Mr. Stroger.
Yes, good morning, Mr. Stroger. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Thank you. Can you raise your right hand for me, sir?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Stroger.
Thank you, sir.
Yes, Ms. Todd, good morning.
Good morning, Your Honor.
You can proceed.
So the offer from the state is going to be 12 months to serve 30 days, credit for time served 10 days, with the balance probated, a theft class, and for a stay away from the Dollar General located at 4894 Old National Highway.
So you want him to have another 10 days in jail or so?
Yes, Your Honor.
All right, what's his history?
Let's see, Your Honor, he does have a total of 24 cycles. If we could have pre-trial go through that, or I could go through that myself if you would like.
Does he have any other theft?
He does have a couple of theft convictions back in 1988 and 2000. Those would be the most recent ones as far as theft goes.
Okay, thank you.
He does, however, Your Honor, have an open warrant out of Jonesboro. That's going to be for a failure to register as a sex offender.
All right.
Your Honor, that's been completed. As a matter of fact, he's been in continuous custody since the date of this offense. He spent a certain number of days in our jail, then he went to Clayton County, which is Jonesboro, the county seat. Took care of that, and now he's back in our jail. He has not been out of custody since January 24th, 2022. According to him, I have not checked that out, but I can do the work if necessary.
Yes. I have that he's been in custody 14 days at the Fulton County Jail, and I would take it that it's on this charge.
That would make sense. On the calendar, it's saying something about 81 days, but that would have been immediately after this arrest.
That would have been, he got a signature bond on that case back, on April the 18th of 2022, where he was booked in back on January 26th of 22, where he served 83 days for some other charges that he was in for felony, and they gave him the signature bond on this case, and he was still in jail on his felony charges until he went to, got time served on him. So that's the reason they're showing the old booking number. So he was booked in November, January 26th of 22, released April the 18th of 2022, and then he got booked in for this charge for FTA on November the 9th of 2022.
Thank you, Ms. Lewis. So to make it simple, Your Honor, we could just amend it to 28 days, credit for time served 14.
Thank you, Mr. Walker. The court appreciates that. So this will, in that case, Mr. McLean, he will be released. Okay, you understand, Mr. McLean?
Yes, Your Honor. Now the theft class, I've explained to him how to conduct himself to get defined and complete and prove a theft class, and how to report to probation.
Okay, very good. Mr. Stroger, it's my understanding that in case 22 CR 002283J, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Mr. Stroger, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the theft class, it'll go to a non-reporting status, okay?
Thank you, sir.
Thank you, Your Honor.
Good luck to you, Mr. Stroger.
Thank you, sir.
Position number 1, Adams, 4 North.
All right. Good
Position,
morning. I'm waiting for Mr. Ford to get ready before I proceed, okay?
Thank you, Your Honor. Appreciate it.
Okay.
I'm all set.
All right. Good morning, Mr. Adams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. How you doing?
I'm doing well, thank you, sir. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. It's my understanding, Mr. Ford, that this is going to be a plea. Is that correct? Negotiated?
It's a negotiated plea, Your Honor.
Okay, very good. Ms. Sari?
Yes, Your Honor. The offer in this case is 12 months to serve 17 days, credit for time served 17 days, the balance suspended, nothing further.
Mr. Ford?
Yes, we do concur with the recommendation of the state, Your Honor, and we do stipulate to the fact that this the 90.
Mr. Adams, it's my understanding that in case 22 CR 007626Y, you wish to plead guilty to possession of marijuana less than an ounce and willful obstruction of law enforcement officers. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Adams. Good luck to you, sir.
Thank you.
Who do we have next?
Position 13, Mr. Ferguson.
It's also going to be a bond hearing. Good morning, Mr. Ferguson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning. Yes, I do agree.
Okay, thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Ferguson. Mr. Ferguson, you have been charged in case 22 CR 000903J with battery, family violence, and 3 counts of cruelty to children in the 3rd degree. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations? Mr. Ford?
Yes, we do, Your Honor.
How do you plead, Mr. Ferguson? Guilty or not guilty?
Guilty.
We will record your not guilty. Your not guilty plea. You case will be returned to the division judge, and you will get notification of your next hearing date. So apparently, I gave him this bond back in February 22nd. Of this year. It was a signature bond at that time through pretrial. Pretrial did not accept him initially, so it went through pretrial per the judge, which means that I went out on a limb for him and ordered him to go through pretrial, given that I was giving him a signature bond. What happened, Mr. Ford?
Your Honor, I have it down for a $1,000 good bond. Did you?
Oh, no, I got a felony charge.
Okay. I have it here, Your Honor. He did get charged with a felony after he was out on bond. And that's the reason we're asking for the signature bond to be reinstated, Your Honor, because he feels that he could possibly make the bond if this bond was reduced. My client is a high school grad, Your Honor, associate's degree from Lincoln College. He was working at Fresh Point Warehouse, making a pretty good wage. He has 4 children, Your Honor. That's the reason that his family is trying to get it reduced a little more so he could actually get out on bond. He has children ranging from the ages of 2 to 12, 4 children. He has a stable address. I have a telephone number for him, email address. He's been in Georgia his entire life, Your Honor, and 2 of the children are his dependents. I have a telephone number for his father. So at this point, Your Honor, we're asking if you could reinstate the signature bond to give him, and he's been a lifelong resident of Georgia, so he's not at risk of flight. So if we could get the signature bond reinstated, Your Honor, it would give him an opportunity to get out of jail and to be with his family.
Ms. Bostic, are you with me?
Yes, Judge.
Did he complete that anger awareness class?
Let me check on that. Ferguson. What 144? Orientation phone class, anger management. He missed it. The first time was late and rescheduled. So he missed it the first time and was late and was rescheduled when he was scheduled to do it the second time. So no, he did not do it.
Okay,
Your
so,
Honor, Your Honor, my
yes,
client mentioned to me that he did do a anger management course at Georgia Works, which is the Gateway area. And so he was trying to do something, Your Honor.
And Your Honor,
Ms. Sowry?
yes, I was gonna say if the state may be heard regarding this case.
Well, I'm not inclined to, I'm happy to hear you, Ms. Sowry, but at this point, I'm not inclined to reduce the bond. Yeah, I've given him a chance. I gave him a chance myself because it came to pretrial per the judge. The bond was only $1,000 signature bond. And he violated that bond. It does not, they do not have any indication that he's completed the one class that I asked him to complete. As such, Mr. Ford, I'm not willing to go back out on a limb for him. Good luck to you, Mr. Ferguson.
This is gonna be on the add-on position 2, Mr. Razor.
Okay.
Your Honor, we apologize. We have not, Mr. Razor was a late add-on, and we have not had an opportunity to speak with him. So we'll speak with him. That's why we're here. We'll speak with him.
Okay.
For the end.
All right, so we'll give you the opportunity, Mr. Ford. Who can we take next then?
Position 35, Mr. Person sits off.
And let's see, I have down that there's a private attorney in this case. Do we have anyone on the line that's representing Mr. Person?
I see a Joel's iPad. I'm not sure if that's him, maybe. I could be wrong.
Judge, I represent Zenard Brownlee.
Oh, sorry.
Okay. So, Mr. Person, do you know who your attorney is?
Gabe Banks.
Okay. We don't have an entry of appearance for Mr. Banks, Mr. Person. So we're gonna have to raise to see if he's actually representing you. As this is not a recommendation for a time served plea, and given that your counsel's not here, we are going to have to reschedule this till next week's calendar.
Your Honor,
yes,
I apologize.
So that's going to be the 29th. All right, so we're going to have to reschedule Mr. Person for the 29th to figure out if Mr. Banks is representing him. And given that, as I said, given that this is not a time served plea, he will still be in custody next week. As such, we will reschedule until next week. All right, we'll see you back next week, Mr. Person.
Ready.
Who do we have next?
Your Honor, can I just interrupt for a moment? Mr. Razor, which is the add-on number 2, this is a 2007 case. And I was waiting for an announcement. Mr. Walker and I talked about this last night, and we don't have an offer at this time on this particular case. So at this time, we may either have to reschedule it till the solicitor's office can further look into this matter.
Okay, is this on Mr. Razor?
Yes, Mr. Razor, who was the add-on number 2.
Okay, so you want to reschedule him for the next week, the 29th?
If Mr. Walker has an offer, I can talk with him now, but I know that this was not a file that he could get off of Odyssey, so he had to try to find the file on it.
I will give him a first in life offer if he would like to take the plea, which is 24 hours, credit for time served, balance probated, $300 fine, 40 hours community service, risk reduction, ADET, and VIP.
I'd definitely like to do that, Mr. White, but if you could go a little bit slower, I'll write it down and I'll talk to you.
I'll put it in the chat.
Mr. Walker, I don't have a computer in front of me.
I'm sorry.
Yeah.
Okay, so 12 months to serve, 24 hours. Credit for time served, 24 hours. Balance probated. A $300 fine. 40 hours community service. Risk reduction. ADET, which is the alcohol and drug evaluation, and a victim impact panel. He can plead to one of the DUIs, and everything else will be authorized.
Okay, so if he pleads to the DUI less safe, then everything else will be dismissed.
Yes, sir.
All right, then thank you, Mr. Walker.
Walker, can you send that to me in the chat? Ms. Lewis.
Yes, Ms. Lewis, I'll be glad to do that.
Let's see, I know that we, courtroom 2, I don't know if you still have him there, but I know that we did call Mr. Brownlee's case early. His counsel wasn't here, so we put it off. Is this Mr. Q?
Yes, sir. And I apologize, Judge. I got the notice at about 6:30 last night. Didn't realize we had court today until
That's
just.
no problem, Mr. Q. What are we going to do with Mr. Brownlee today?
Well, Judge, he has 4 pending DUIs in Fulton. He's got 1 in DeKalb and I think 2 in Cobb County. And he's got an unserved felony aggravated assault warrant out of Cobb County. So I think he's in I apologize what judge this is assigned to, but I believe his bond was actually revoked. He went into bench warrant status, but I believe that I know the state filed a motion to revoke bond. So at this point, we're just going to plead not guilty and try to find some type of global resolution to try to resolve all of his matters.
Okay. Has he, Ms. Lewis, has he already been arraigned on these charges?
He was on the calendar and it was be set from Judge Taylor.
Yeah, he was on the trial calendar when he went into.
I'm pretty sure he has.
Okay, so given that he's already been arraigned on the charges, I guess it'll be the cases will be returned to the division judge, and you all will move on from there.
Thank you.
Okay.
Right.
Thank you, Judge. Have a blessed day.
All right, do the same. Thank you.
Bye-bye.
Okay, who do we have next?
Position number 12, Phelps, 4 North.
This is going to be a bond hearing also. And who's representing Mr. Phelps?
Oh, Ford. Hey, Mr. Ford. Ford. You're doing position 12. That's your case.
Apologies, Your Honor, again. What number are we on?
Position 12.
Position 12.
Desmond Phelps.
All right. Let me know when you're ready, Mr. Ford.
All right, just give me a second, Your Honor. I apologize.
You're fine. You're fine. Just let me know.
All right, we're all set now.
All right. So this is going to be an arraignment, or has he been arraigned already?
I don't know, Your Honor, but we definitely want a bond hearing because at this point, I don't see a bond.
No, he's not gonna arrange. There's co-14 Jones. FDA. Bench warrant. This bench warrant paper from Judge.
Okay. All right. So let me arraign him. Mr. Phelps, good morning. I'm Judge Jarrett. This is a state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. Mr. Phelps, you've been charged in case 18 CR 004720A with the possession of a pistol or revolver by a person under 18 years of age. This charge carries with it a maximum sentence of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead, Mr. Phelps? Guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Mr. Ford, it's my understanding that Mr. Phelps has missed court on numerous occasions in front of Judge Roth, which is why Judge Roth issued a bench warrant on this matter. If he wants to have this addressed, it's the practice of this court to send him back to Judge Roth so that Judge Roth can decide whether or not he wants to lower that bond amount. So I'll give him the opportunity to go back to Judge Roth.
Your Honor, does he have, I don't know, I didn't see a bond in Odyssey, so I just like to know what that bond is.
They only have this charge associated with booking streams, so the rent must not be accurate. Because it's not on his booking stream. He's in jail for a felony charge. How do you discharge?
Okay. Ms. Sari, do you have a bond on this case?
I can check, Your Honor.
And Your Honor, while Ms. Sari is looking for if there's a bond, Your Honor, this is the case that we handled similar last week. This is the possession of a pistol or a revolver, which at this point, that is not a crime at this time. It's for an underage individual. My client is now 21, will turn 22 on November 25th. Your Honor, we feel that a signature bond is appropriate due to the fact that the crime that was committed is no longer a crime. He could possess, he's here today at 21 years old, being charged with this offense. Your Honor, I feel he could return to court because he is a lifetime resident. I have telephone numbers for his mother. He has a stable address, stable telephone number. He has a GED, and he actually works in a law service business with his father. So, Your Honor, I feel that that because we don't have a bond, he should be given a bond today, and that should be a signature bond, Your Honor, due to the fact that the crime that he's being charged with is no longer a crime.
Just for clarification, possession of a pistol by someone under the age of 18 is still a crime.
But Your Honor, my client has not been,
Judge, just a second. I'm sorry. On his booking screen, it's showing that he has a $6,000 bond on that possession of a pistol.
And Your Honor, that bond was given through, I have a pretrial bond on this case, and subsequently he picked up 6 additional, he was arrested 6 additional times after that bond, so it was surrendered. And Your Honor, as you've already stated, the defendant did fail to appear multiple times regarding this case, 2018, 2019, 2021, 2022. He was arrested 2 months after this incident for possession of a Schedule 1 and possession of drug-related objects. He used his first offender on that. In 2022, he had a robbery, ag assault, terroristic threats guilty conviction. 2022, criminal damage to property, and simple assault that's open in Clayton. So, Your Honor, he does present a significant risk of danger to the community, being underage with a gun and then later picking up 6 additional charges. He also has an open felony case, possession of a firearm by a convicted felon. So, Your Honor, the state's position for a bond is for it to remain as set. He was already given a pretrial bond, violated that. So we do not feel he is a good candidate for a signature bond at this time.
And you're telling me, Ms. Sari, that he presently has a $6,000 surety bond on this charge?
That I didn't say. I know it was a pretrial bond. Let me double check the amount.
Let me clear this up for everybody. He is not being held for this charge He had a $6,000 surety bond through a second chance bonding company that he made on July the 4th of 22. Judge Wall held out on the bench warrant due to if he didn't appear on the next court calendar. And since he was in jail, the judge did not issue the bench warrant on this case. So he's not being held for this charge. He is out, he still has a bond on this charge, which is a $6,000 surety bond through a second chance bonding company. Does that clear everything up, everybody?
Yes, ma'am. So it
Yes,
sounds
Judge,
like
he's
bond
in
is a-
custody on a possession of marijuana, 20 SC 179. What's the last four digit? 5904, that he was booked in October the 24th. That's what he's in custody on.
So bond on this case is a moot issue.
Thank you.
So we'll just ask that he's arraigned. If he has not been arraigned, and we send further notice to trial.
That's correct. He was not arraigned, he just was arraigned.
All right, so anything else when he's been, I just arraigned him, anything further?
Nothing further, Your Honor.
Nothing.
All right, good luck to you, Mr. Phelps.
So what they saying? So what, I got a further notice?
Yes, your case will be returned to the division judge and you will get notice of your next court date, okay?
So no bond, right? You said no bond for this.
I'm gonna allow you to speak with your counsel at a later time, Mr. Phelps. So Mr. Ford will be speaking with you regarding this, all right? Who do we have next?
Position 44, Walker. That's a conflict case.
44. 44. It's 44, right?
Position 44, Mr.
Yes,
Walker.
Mr. Walker. Okay. Do we have a conflict attorney available for Mr. Walker today? Okay, well, we're gonna have to see if there's a conflict attorney available to move forward and who has been assigned to him.
All right, come on, Mr. Johnson. Position 22, Mr. Johnson.
Judge, this is gonna be a negotiated plea, Your Honor.
Okay, give me just 1 second.
What position?
Give me,
22.
give the court just a moment, please. Okay, the court was trying to clarify who is Mr. Walker's attorney. Apparently it's Ms. McLeod. We're going to try to raise Ms. McLeod to see if she can join court today so that we can move position 44 forward this morning. All right, so please tell me again who we have.
This is position 22, Mr. Johnson.
22. And I have that he was supposed to be reset.
Judge, after making those announcements, I ended up getting to talk to him, so it's gonna be a negotiated plea.
Okay, very good. Thank you. Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yeah, you can put your hand down. Thank you, sir. Ms. King?
Yes, Your Honor, the state's offer is 10 days to serve, balance suspended.
And Judge, that is our understanding of the offer, of which we do agree, and do stipulate the factual basis, ID, and venue.
Okay, Mr. Johnson, it's my understanding that in case 22 CR 007719J, you wish to plead guilty to possession of marijuana less than an ounce, possession and use of drug-related objects, and willful obstruction of law enforcement officers. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Is anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Johnson. Good luck to you, sir.
Yes, sir.
Position 17, Mr. Perry. No, Mr. Howard.
Let's see. Mr. Howard is going to be a non-negotiated plea. Is that correct?
Give me just a second, Your Honor. Yes, the only issue is nolo, Your Honor. We concur with the state's recommendation on the jail time and condition.
Good morning, Mr. Howard. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Howard, can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, sir. Ms. Howard?
Yes, Your Honor. Regarding this defendant's history, he does have multiple convictions for battery as recent as 2020, an ag assault, terroristic threat, battery conviction, simple assault, guilty conviction, 2018 ag assault, guilty, 2017 battery, guilty. It goes back to the 90s with a battery family violence guilty conviction against his mother. Your Honor, in this case, the victim, whose name is Darren Jefferson, he was working as security when the defendant was standing outside screaming and yelling at him. The victim tried to speak with the defendant to the side, but the defendant then punched the victim in the head multiple times. The victim had to mace the defendant, but the defendant continued and re-engaged and struck the victim again. Eventually, the victim was able to get back outside of the gate, and he did call 911. And the defendant told the victim that if he came outside that gate, he had something for him. This defendant does present a risk of reoffending. The history that I read, all of those victims are different people. So he does present a danger to the community, Your Honor, and he has a 2019 FTA. That's why the state would object to a NOLO in this case. So the offer is 12 months to serve, 111 days credit for time served, 111 days the balance probated, 6-week anger management, stay away from the incident location of 201 Washington Street in Atlanta, and no contact with the victim.
Mr. Ford?
Thank you, Your Honor. Your Honor, my client is a high school graduate, and he's on disability, Your Honor. And I did have a note here that I was going to ask for the anger management to be reduced from 6 weeks to 4, due to the fact that my client is on disability at this time. He has a stable address. Your Honor, he has not used a NOLO in the last 5 years. So at this point, we're asking that he be given the opportunity to use his NOLO at this time.
Okay, I'm not going to allow him to use a NOLO, and I will be accepting the state's recommendation if he would like to accept it.
My client. Mr. Howard, did you hear what the judge had to say? Are you willing to accept do a guilty plea on this particular charge?
Yes.
Okay. All right, Your Honor, we can continue. And we do stipulate to the factual basis venue and ID.
Mr. Howard, it's my understanding that in case 22 CR 007750F, you wish to plead guilty to simple battery, terroristic acts, and simple assault. Is that correct?
Yeah, correct, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept your plea as negotiated, Mr. Howard. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Yes, Your Honor.
All right, good luck to you, Mr. Howard.
All right, thank you.
Position 44, Mr. Walker.
Yeah.
Have we raised? We were trying to get in touch with Ms. McLeod. I believe that she's representing him. Ms. Lewis, have we tried to reach her?
Yeah, they're in the process of contacting her now. I
Okay.
haven't gotten them word yet.
All right, thank you.
Next, we'll have position, Mr. Shaver, probation, position 2.
Okay, thank you. Good morning, Mr. Shaver. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I know.
I'm doing fine. Thank you, Mr. Shaver. Officer Harris?
Yes, Your Honor, Mr. Shaver was sentenced to probation on May 1st, 2018 to 12 months to only pay a fine of $278. Mr. Shavers never reported to our office. He missed a prior hearing on December the 19th, 2019 with Judge Etline. That's why a warrant was issued. As of today, Mr. Shavers only have 30 days left on his case. Probation recommendation is the time service case.
All right. Mr. McLean?
I would concur, Your Honor. It is an old case and it's just it's headlights. He didn't have the money. He's sorry this happened this way, but time served would be a good solution.
All right, good luck to you, Mr. Shaver.
All right, thank you.
Thank you, Your Honor.
You're welcome. Have a good one. And Ms. Harris, does that conclude your business?
Yes, and can I make an announcement to the public defenders? Can you all send me the petitions before Judge Morrow leaves? Because I'm not going to be in my office, and we want to make sure both of the defendants are able to get out of jail before the holidays.
Okay, did you all hear that? You need to get Officer Harris the paperwork so that I can get it signed so that they can get out before the holiday. So Ms. Harris,
I didn't hear that.
I send it to everyone, Mr. Ford, except you. I sent it to Mr. Howard, Ms. Helen, Mr. Finley, and Mr. McCoy. I didn't send it to you.
Okay, because I don't have the petition for my case. That's all. That's why I stepped in.
Okay, I can send it to you, Mr. Ford. That's fine.
This is easily solved if we ask you to sign our name by express permission in the spot for the defendant's lawyer.
I'm not able to do that legally.
Email it to me. Email it to me. And Your Honor,
Okay, I can Mr. Ford.
you send the paperwork to for your cases, Your Honor?
say it again.
Who are we sending the paperwork to for your cases? Because
To Ms. Lewis.
yeah, because when I put Ms. Lewis's name in this morning, it shows that she's out of the office, so the mail didn't go to her. I don't think she got it. So I just wanted to make sure.
Mr. Ford, this is Ms. Lewis.
All right.
Mr. Ford, I'm back.
Oh, yeah, I see you. All right, you're back. All right, thank you.
I was out of the office, but I'm back today and I changed my status.
I just wanted to make sure.
Okay, I'm right here.
That concludes my business, Your Honor. May I be excused?
Yes, have a good one, Officer Harris. Thank you. All right, who do we have next?
Position 20, Mr. Jarrett.
And Judge, I had time to speak with Mr. Jarrett. This is now going to be a negotiated.
Okay. And Mr. Jarrett is still under oath as I arraigned him previously, I believe. Ms. King?
Yes, Your Honor. The offer is 12 months to serve 84 days, credit for time served 42 days with the balance suspended and no further contact. Now, no further contact is with Jessica Smejal. First name traditional spelling, last name Smejkal.
All right, Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which we do agree. Do stipulate the factual basis, and you and I be Judge.
Okay. Mr. Jarrett, it's my understanding that in case 15 CR 001339Y, you wish to plead guilty to simple battery, is that correct?
Yes, Judge.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Jarrett. Good luck to you, sir.
All right.
Thank you.
I'll see if I can.
34.
How you doing?
Mr. Perry.
Okay. I have that he's represented by Andrew Hall. Is Mr. Hall on the line? Good, thanks.
That's yours, McLean. 34? Oh, this.
And this is a time served offer, Your Honor.
All right, so we're gonna see if we can raise Mr. Hall. I do have him on the calendar. So can we see if we can get someone to see if he's gonna appear this morning? We'll have to go to someone else until we figure out where his attorney is.
Okay, can we do position number 24, 3 South?
Hold on, we have 1 second for me.
Mr. Hall represents the bonding company on this case, not the defendant.
Okay.
The bonding company.
All right, well, I've got him down as the attorney that's on the
Yeah,
sheet,
because
so,
the way it's associated in the system.
okay.
It says interference for the surety by the attorney.
All right, so he does not have a private
No,
attorney?
he does not. And his
Okay.
family's here in the courtroom today.
All right. Let's see. One of the public defenders,
I'll take it.
can we get, apparently he does not have a private attorney. Can we get someone to talk with him this morning?
Yeah, sure. I'll speak to Mr. Is Terez Sharon?
Right, position number 34, Mr. McLean.
Right. His offer is simply time served, balance suspended, and I'll speak to him about the case.
Okay, thank you. We appreciate it. Can we take someone else while Mr. McLean is speaking with Mr. Perry?
Position 24, 3 South.
How you doing?
All right, so position 24, Mr. Finley, is that your case?
Yes, Judge, it's my case and it's a negotiated plea.
Okay, very good.
No, we're not doing this case, we're doing.
Okay.
Mr. Jones.
Yes.
Good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, Mr. Jones. Ms. King?
Yes, Your Honor. The offer is 12 months to serve 36 days, credit for time served 18 days with the balance suspended, no further contact, and a stay away. The stay away is from 178 Stratford Road Northwest, and no further contact with Karen Imes, first name traditional spelling, last name I-M-E-S.
Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which we do agree, and do stipulate, Your Honor, to the factual basis I do.
Mr. Jones, it's my understanding that in case 22 CR 007644C, you wish to plead guilty to willful obstruction of a law enforcement officer and criminal trespass. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Jones. Good luck to you, sir.
Thank you. So that means I'm.
Position 38, Price.
And this is a negotiated plea?
Yes, Your Honor. Where's Terry?
All right. Good morning, Mr. Price. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Put the microphone for me, Price.
Was that, okay, you can put your hand down. Thank you. Ms. Todd?
Yes, Your Honor. So the offer is 12 months to serve 26 days, credit for time served 17 days with the balance suspended. Excuse me, the balance suspended. We also ask for a stay away from the racetrack at 1180 Virginia Avenue.
Mr. McClain?
Your Honor, he stipulates to all the elements and asks the court to accept his negotiated plea. This will not involve probation, so there won't be a contact information sheet involved either.
Okay. Mr. Vincent, it's my understanding that in case 22 CR 007651A, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Thank you, Mr. Price. I'll accept the plea as negotiated. Good luck to you, sir.
All right.
Thank you. I see that Ms. McLeod has joined us. Good morning, Ms. McLeod.
Position 44, Mr. Walker.
Okay, give me just a moment, Ms. McLeod.
Good morning, Your Honor.
Good morning. You have position number 44, Mr. Antavius Walker, that's on the calendar this morning. Have you already had the opportunity to speak with him regarding this?
And I would like to.
Okay. Is Mr. Walker still in courtroom 2?
Yes, he is, Judge.
All right. Can we facilitate having Ms. McLeod speak with him this morning?
Okay.
Okay. Thank you. So if he doesn't. So
We can
we'll
move on to the next case. This is going to be on the add-on calendar, position 2, Razor.
Okay. And Ms. McLeod's, her client is Antavius Walker, position 44.
Yes, Your Honor. I'm going to, once I speak with my client.
And Ms. McLeod, I just put the offer in the chat on that position for you.
Oh, yeah, I saw it. Thank you, Mr. Walker.
I'll give you a call, Ms. McLeod.
Okay.
Appreciate it. Thank you.
Thank you. Tell me again who we have.
We have Ronnie Razor, add-on 2.
Okay, thank you. And this is going to be a plea?
Yeah, negotiated plea, Your Honor.
Okay.
Honor, the state's recommendation is 12 months to serve, 24 hours, credit for time served, 24 hours, balance probated, a $300 fine, risk reduction, ADET, 40 hours of community service, and a victim impact panel.
Okay, and you'll be notified.
Yes,
other
sir. This is
charges?
less safe and will not prosecute additional charges.
Okay. Let me speak with Mr. Razor first, though. Good morning, Mr. Razor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give in this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Razor. Go ahead, Mr. Ford.
Your Honor, just one correction. Mr. Razor has informed me that he has been in custody since Wednesday of last week. Mr. Walker, are you willing to give him serve 7 days or credit for
Yes.
7?
Yes, sir.
All right, thank you. Your Honor, we concur with the state's recommendation. I've spoken with Mr. Razor, and we do stipulate to the fact-based genuine injury.
Okay, so it's going to be 12 months to serve. How many days credit for time? How many days served?
7.
5 days now, as of today.
Ms. Lewis is telling me that he's been in jail 5 days.
We'll go with Ms. Lewis.
Okay, thank you.
He was at the city jail for 2 days, Your Honor. That's all. That's
Okay,
But we'll do 5 days.
all right, very good. Mr. Razor, it's my understanding that in case 08 CR 333-612, you wish to plead guilty to driving under the influence of alcohol less safe. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Razor, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Mr. Razor.
Position 43, 3 South.
And that was position 4, Mr. Bishop, is that correct?
43.
Oh, 43, okay.
Mr. Jarrett Thomas.
And this is a negotiated plea.
Yes.
Good morning, Mr. Thomas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Todd?
Thank you, Your Honor. The state's offer is 12 months to serve, 22 days, credit for time served 12 days, with the balance suspended, and a stay away from the MARTA Peachtree Center Station at 216 Peachtree Street.
Mr. McLean?
Mr. Thomas stipulates to all necessary elements and asks the court to accept this negotiated plea.
All right, Mr. Thomas, it's my understanding that in case 22 CR 002954H, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir. No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Thomas. Good luck to you, sir.
God bless you, sir.
Thank you, sir. Who do we have next?
Judge, I was trying to get in contact with Ms. McLeod. I don't know if she's available.
She put her number in the chat. Would you like me to read it out to you? Would that be easier?
No, I've been trying to call. She's not picking up.
Oh, understood. Thank you.
Ms. McLeod, are you with us? Okay, well, we'll see if we can get her. Is there someone that we can go to while we're waiting on Ms. McLeod?
That's our last case here, Judge. It's just Ms. McLeod's case.
Okay.
You can go to South Annex if you like. Or, oh, never mind. Okay, we do have another case in here, but McLean is talking to Mr. Perry.
Okay, all right. So let's see, South Annex, are we ready with anyone?
Yes, sir. We're ready, Judge.
Who do we have?
I have Adolf, position number 2.
Okay.
I think that's Mr. McLean's case. Do you have Brittany Anderson?
Apparently, Mr. McLean is speaking with someone. Can we go to one of Mr. Ford's cases?
Number 1, Brittany Anderson.
She's on the add-on calendar.
Yes, sir. I have her.
Okay. And this is going to be a negotiated plea.
That's correct, Your Honor.
Good morning, Ms. Anderson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. Ms. Francis, is this your case? Okay, you're on mute.
It is, Judge. Good morning. Nice to see you.
Good morning. Nice to see you as well. Thank you. You can proceed.
Yes, Judge. The state's offer in this case is a guilty plea to battery with conditions of 12 months to serve 46 days, credit for time served, 46 days, balance probated, 2-day anger management class, and 40 hours community service.
Mr. Ford?
Thank you, Your Honor. We concur with the state's recommendation, but I do have about 49, possibly even 50 days of jail time. So could we amend that to 49 days?
Any objection by the state?
None, Judge.
Okay. Anything further, Mr. Ford?
Your Honor, I have spoken with my client on this, and in speaking with her, Your Honor, it appears this may be her first offense. And so at this time, we're asking for a first offender. And then asking that her fees be waived on probation, and then after she completes her condition, that her probation be terminated.
Your Honor, this defendant has 19 cycles. I'm not sure where Mr. Ford got that in. Well, he said he got it from his client.
It appeared that she had some cycles, but I didn't pull up 19. But the ones that I had pulled up, that she said a couple of them had been dismissed. So, Your Honor, so that's why we asked for first offender. But if she has 19 cycles and she's been charged with all 9, with a few of those, and we will withdraw our first offender.
Okay. Anything further?
Nothing further, Your Honor.
Ms. Anderson, it's my understanding that in case 21 CR 007969Y, you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I am. I do.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Anderson. I am going to waive your fees while you're on probation to help you get and stay on your feet. And as soon as you complete the terms, it'll go. It will go to a non-reporting status. Okay.
Okay.
All right. Good luck to you, Ms. Anderson.
Is the FTA gone too as well?
Yeah, that was another question, Your Honor. She was charged with an FTA on this particular case, the battery case. And she was then wondering if, I'm assuming the FTA will go away because she has a $15,000 bond, 10 on this case and 5 on the FTA.
I don't have any indication of an FTA. Ms. Francis, do you?
I don't either, Judge.
Okay, so Ms. Anderson, the FTA is now gone, so you have no bonds and your cases are done.
Okay, so I'm going home. Okay.
Let me make sure. Let me make sure. Ms. Lewis is looking into it for me.
The FTA was discussed by Judge Williams on October 13th.
Okay.
Dismissal already on the.
Okay, the FTA has been dismissed.
Okay, thank you.
All right, have a good day, ma'am.
Thank you.
Thank you, Judge.
Position 44, Walker.
And what are we gonna do with Mr. Walker this morning, Ms. McLeod?
He is going to be arraigned, Your Honor. He wants to have a trial on this case.
Okay. Let's see, Mr. Walker, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Mr. Walker, you've been charged in case 22 CR 007574A with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. McLeod?
Your Honor, I do.
How do you plead, Mr. Walker? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Yes, sir.
Thank you, Your Honor.
Yes, thank you, Ms. McLeod.
Judge, we're completed here in courtroom 2.
All right, very good. I will see you this afternoon, I guess.
Judge, my business is before the court today. May I be excused?
Yes, thank you, Ms. McLeod. I appreciate it.
You're welcome.
Judge, we do have one more. It's going to be Mr. Perry. He's actually from another floor coming to our courtroom.
Okay, so it's going to be,
position 34 when
Okay.
McClain is ready. Mr.
Okay.
McClain, are you ready?
Yes.
Okay, come on, Mr. Perry.
Mr. Perry would like me to fill out the paperwork and have him do the negotiated plea.
Is this number 34?
it is, yes. And I just would like to indicate that I have some of Mr. Perry's relatives in the courtroom with me, I believe, this morning, so they're here with me. Whenever you're ready, Ms. McLeod, Ms. McClain, let me know, please.
Correct.
Okay, all right, Ms. King.
Yes, Your Honor, the state's offer is 12 months to serve 60 days, credit for time served 30 days with the balance suspended, no further contact and a stay away. That's no further contact with Amaya Evans, A-M-A-I-A, last name traditional spelling, and a stay away from 190 Campbellton Road, apartment 191.
Is that your understanding, Mr. McClain?
Yes, Your Honor.
Anything further?
Nothing further. He wishes the court to accept the negotiated plea.
Mr. Perry, it's my understanding that in case 20 CR 004727Y, you wish to plead guilty to battery, substantial physical harm, battery, and 2 counts of simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation? Was that a yes?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury? You have to speak up for me, sir.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I will accept the plea as negotiated, Mr. Perry. Good luck to you, sir.
No further contact. No further contact for the body count.
Judge, we have position 4, Mr. Bishop.
No further contact. Evans was the only name that was given. The last name was Evans.
McClain.
Okay, this is position.
Position 4, Mr. Bishop.
Okay. And this is gonna be a arraignment and a bond hearing.
That's correct, Your Honor.
Mr. Bishop, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Mr. Bishop,
yes.
can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Mr. Bishop, you have been charged in case 21 CR 006809F with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do.
How do you plead, Mr. Bishop? Guilty or not guilty? Was that a not guilty?
Yes, sir.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you will get notification of your next hearing date. May I get this bond? Okay.
And, yeah. Everybody in the box.
I need period. I need period.
Okay. All right, so, Mr. Ford, I set this bond back in November of last year. It was a $3,000 signature bond through pretrial. It is my understanding that he failed to appear in front of Judge Richardson on numerous occasions. The first occasion he failed to appear, he came back and Judge Richardson set aside the bond. The second time he came back, well, the second time he missed, the next time he missed court again. So as such, I'm going to have him return to Judge Richardson if the bond is to be modified at this point in time.
Thank
All right.
you.
Good luck to you, sir. Thank you, Ms.
All right, Judge, we're completed here in courtroom 2 as far as my guys.
Okay, thank you. I appreciate it.
Thank you.
Good morning, Your Honor.
Also a pretrial.
Are you ready for the South Annex, sir?
Yes, I am, Officer Milton. Good morning.
Good morning. Before you is position 16, Ms. Hill.
Let's see. I have hold for announcement for Ms. Hill.
Okay. We can go to another one.
No, we can, I don't have a counsel ready yet, so give us a moment.
Okay.
Who's representing Ms. Hill? Position 16?
Your Honor, Ms. Hill is my case.
Okay, I have hold for announcement. What are we doing with Ms. Hill?
Ms. Hill, who I think is number 16, as well as Ms. Adolf, who I believe is number 2, are both going to be negotiated pleas, Your Honor.
Okay, are you ready, Mr. McLean? She's before us.
Yes, we are.
Okay, good morning, Ms. Hill. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. Hill, you've been charged in case 22 CR 005748J with battery family violence. Ms. Sorry.
Yes, Your Honor. The offer in this case is 12 months to serve 76 days, credit for time served 38 days, the balance probated, an FFIB course, no contact with the victim Tavoris, that's TAVORRIS, last name Williams, and to stay away from 6149 Old National Highway in South Fulton. Nothing further, Judge.
Mr. McLean.
Your Honor, we stipulated as to all necessary elements. Tavoris Williams is the person that I called on the phone this morning, and he was adamant that this should be no further violent contact, not no contact. So that was his understanding of the way the bond's gone. They are parents of the same 2-year-old child, and they don't want to do that third-party transfer. They get along. Mr. Tavoris Williams is on the screen. If he would open up his video and unmute his mic, that would be helpful. There we go. Hi, Mr. Williams.
Hey, how y'all doing?
Did you hear what I say, and do you confirm it?
Yes, I does.
Okay, thank you.
No objection from the state.
Okay, all right, so there'll be no further violent contact in the order. Anything further before I take the plea?
Nothing.
All right, Ms. Hill, it's my understanding that you wish to plead guilty to battery family violence, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Hill. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Thank you. Okay.
All right, good luck to you, Ms. Hill.
Thank you.
Next, we have position 29, Ms. McCoy.
That's a negotiated plea.
Okay. Good morning, Ms. McCoy. I'm Judge Eric Morrow, and this is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. Ms. King?
Yes, the offer is 12 months to serve 365 days, credit for time served 365 days.
Mr. McLean?
Yes, Your Honor, that's simply time served. So she asked the court to accept her plea as negotiated, and she does stipulate as to identity, venue, and factual basis.
All right, thank you. Can we mute Mr. Williams? Mr. Williams, you're free to go if you don't have any further business before the court. Otherwise, can we get someone to mute him? Thank you. Ms. McCoy, it's my understanding that in case 22 CR 0076738, you wish to plead guilty to battery substantial physical harm. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
All right, I'll accept the plea as negotiated, Ms. McCoy. Have a good day.
Okay, you too.
Next, we have position 45, Ms. Watson. Ms. Watson, come on.
Good morning, Ms. Watson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Thank you, ma'am. Ms. Todd?
Yes, Your Honor. So the state's offer is 12 months to serve 20 days, credit for time served 10 days with the balance probated, a $300 fine, risk reduction, ADET, 40 hours of community service, and a victim impact panel.
Okay. Mr. McLean?
Your Honor, she asked the court to accept her negotiated plea and stipulates to venue ID and factual basis. We discussed whether or not she would ask the court to convert all or part of the $300 fine into additional community service, and she decided she wants to leave it as a fine.
Okay. Ms. Watson, it's my understanding that in case 18 CR 0068858Y, you wish to plead guilty to driving under the influence of alcohol, less safe, and headlights not turned on as required. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes. Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Watson. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
All right, thank you.
You're welcome. Good luck to you, ma'am.
Okay. Next, we have add-on one, Ms. Anderson. Ms. Anderson? She already went. Oh, she already went? Okay, for this. Ask him, Your Honor,
Yes.
Ms. Watson wants to ask you a question.
Okay.
So am I getting out today? Or getting out, am I gonna be released?
Well, as long as you don't have anything holding you, Miss Watson, you'll get out when the jail can process you out. So we'll have to get the paperwork over to the jail. They'll process it and they'll process you out if you don't have anything else holding you, okay?
All right, thank you.
You're welcome.
Thank you.
Arrivederci. Adios.
We're done? Well,
Judge.
Hold on, one second. I've got some more people on my calendars.
What's your name? Adolf. Oh, Miss Adolf, you want to upgrade? I'm so sorry. That's what I'm saying. No, she said another time.
Hey, Judge, I'm sorry.
Yes.
Excuse me. I was supposed to be seeing you at 11 o'clock, but I have yet to hear my name being called.
Okay, Ms. Capers, are you
Yes.
Ms. Capers Walker? Yes.
Yes, sir, that's me.
I have you here, Ms. Capers Walker. We're in the middle of the 9 o'clock calendar. So as soon as I finish this calendar, I will speak with you about your case, okay? And let's see, who's going to be representing Ms. Capers Walker this morning?
I will.
Okay, have you already spoken with her, Mr. McLean?
Yes, Your Honor.
Okay, all right. So we'll be with you, Ms. Capers Walker. Just hold
Yes,
on
sir.
for me. Okay.
Your Honor, is that a revocation hearing or what calendar is that?
That's
She
the bench calendar, yes.
Oh, Mr. McLean, can you put that CR number in the chat? Well, never mind. I'll look it up.
Yeah, we're not chatting here.
Okay.
Okay. And so this is Miss is it Adolf? Adolf? Okay, good morning, Miss Adolf. I'm Judge Eric. Good morning, ma'am. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you put your hand down. Thank you, ma'am. Ms. Sari?
Yes, Your Honor. The state's offer in this case is 12 months to serve 42 days, credit for time served 21 days, the balance probated, a 6-week anger management course, and no contact with the victim, Cyril, that's Cyril, last name Del Cruz.
Okay, Mr. McLean?
There'll be no problem with the no contact. The two individuals do not associate with each other in any way whatsoever. She asked the court to accept her negotiated plea stipulating venue, ID, and factual basis, Your Honor. She understands that with the 6th week of anger management, if she shops around for a provider, and there are many, possibly she could get that done in a day if it's an all-day class doing a marathon session. But we've discussed that extensively, and she went to the court to take her case forward.
Okay. Ma'am, it's my understanding that in case 20 CR 0041788, you wish to plead guilty to battery in a public transit vehicle or station. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Oh, yeah. Yes, sir, Your Honor. Mr. Marcus.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
Okay, I'll accept the plea as negotiated. I am going to waive your probation fees while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Thank you, Your Honor.
All right, good luck to you, ma'am.
Thank you. So can I ask you a question?
Yes, ma'am, go ahead.
So I should be released in the next 48 hours, is all right?
Very probably.
As long as you don't have anything else holding you, okay?
Yes, sir. Thank you very much. Thank you, Mr. Mike.
Thank you.
Your Honor, may I be excused now, please?
Okay. Since you're the only one that I have on, I just want to make sure that I've covered everyone. Well, we do have court. No, yes, you can be excused. Am I going to see you this afternoon?
No, Your Honor, but I will pop on to say hello.
Okay, if I don't see you, have a good Thanksgiving, okay?
Thanks, you too. Bye-bye, everybody.
Thank you. Okay, let's see, what are we doing with position number 32?
Oh, yeah. Yeah, Judge 32, I'm going to submit a waiver for him. I did just want to make sure that he had a bond set before he's being held on.
Yes.
He does.
One moment.
He's being held on some other charges. I just want to make sure for this case.
That's correct. I see a 1,000 surety for this case for him.
Okay. Yeah, so I'll submit a waiver for Mr. Mitchell. He wanted to plead not guilty.
Okay, all right, thank you, Mr. Finley. What about position 39?
Private counsel.
Do we know who's representing?
Position 39?
Yes,
He was released.
he was released, okay.
39, Dwight?
Dwight Puckett.
Yeah.
Released, okay. And, all right, I think that covers it. Are we ready to, before we go over the calendar, can we go ahead and do Ms. Capers Walker, please?
I'm surprised that Mr. Lynch isn't here today, but yeah, that was definitely Puckett.
Okay, it's my understanding that he was released, so that's probably why.
Oh, I'm sorry.
So where are we with Ms. Capers Walker?
Your Honor, I spoke to her whispering on the phone while we were doing other things, of course, in between cases today. I understand she missed court. She gave to me a brief but reasonable sounding synopsis of why she missed court. And I said, well, just that sounds pretty brief. Why don't you tell that to the court?
Okay. It's my understanding that you missed court at some point in time, Ms. Capers Walker, and that a bench warrant was issued given that you missed court. Is there a reason that you missed court?
Yes, Your Honor. I would like to get that bench warrant released because from what I'm understanding, when I went downtown to go to the clerk office, they said that my court date was not sent to me because when the court tried to send me out a mailing information to it, it was returned to sender. So I don't know if y'all had not got the right address for me, but that's the reason why I never received my court date. And that's another reason why my pretrial officer wouldn't know about my court date. Because I'm supposed to call and check to her every month. And I did that. And she didn't have no information on my case or my court date until after my court date was set on November the 7th. When I went to the...
Have you moved since the time that?
No, sir. And y'all have my current address because when I went down to the clerk office, the deputy that re-signed my court date for day had my current mailing address. So I don't know how it was returned to sender when y'all have my updated mailing address.
Okay. So what are you telling me, Ms. Lewis?
She has 2 addresses in the system. Can she verify what address and what city she's supposed to be living in?
Did you hear that, Ms. Capers Walker? Apparently, we have 2 addresses in the system for you. Which can you tell us?
Yes, it's 7878 North Main Street.
Do we have that address?
Jonesboro, Georgia, apartment 4L.
Yeah, and then they also had the Smyrna one also.
So
I never gave that to anybody. Probably got it because it was on my ID, but that address was never given. My address was always 7878 North Main Street.
Apparently, we had Smyrna, Georgia at one point back on July 9th of 2022. So if that was on your ID when you got arrested, that's what they put in the system. Until it got updated on August 2nd of 22. At the time by somebody, I don't know who office updated it, but it's just not updated as of now.
Okay, well, we'll need to update that. Mr. Walker?
Of course, the state wants to say it's the defendant's responsibility to keep her most current address on file with the clerk's office. She had court on November the 7th. It looks like in front of Judge Morrison, she was at FTA. Due to her not showing, we'll ask that the bench warrant is not set aside. I would like to provide more information, but my odyssey currently is frozen.
Okay. And
yes,
hold,
Your Honor.
hold on, Ms. Capers, Walker,
Yes,
hold
sir.
on. This court routinely will set aside a bench warrant on one occasion.
Thank you, sir.
So we're gonna set that bench warrant aside, but know that you've already used your one occasion, so make sure that.
Yes, Your Honor, and I appreciate this one occasion. It would never be occasion. My first court date was August 26th, and I appeared on that court date even when I had COVID. So I'm not going to purposely or intentionally miss court. That
Okay.
wasn't my fault that I missed that court date on the 7th, Your Honor.
Well, we don't expect you to show up if you have COVID, Ms.
But I
Capers.
still did. That just shows you that I'm going to come to court,
Okay,
no
so
matter what.
I'm gonna set it aside, okay?
I appreciate that. Thank you so much.
All right, you have a good holiday. Thank you, ma'am.
You do too. So do you know when I go to court again? I'm sorry.
I don't, they will send you out, Judge Morrison's court will send you out notice of your next hearing date, okay?
Yes, sir. With my pretrial officer, Ms. Dixon, will have information as well that I'm supposed to check in with.
That I do not know, so you'll have to ask her, okay?
I appreciate that, Mr. Mayor. Maro, you have a wonderful Thanksgiving. Blessings to you.
You do the same. Thank you, ma'am.
Thank you.
Okay,
McClain,
say it again?
who was that? Mr. McClain that represented her?
Yes.
Mr. McClain, this is Ms. Wood. I will need a warrant for set aside warrant, please, sir.
Okay, I'll be back. I'll be back at the 100 Peachtree Street building, able to respond to emails in about just within a half hour after we quit here.
Okay, so
Hello.
Yes, who's on the iPhone?
Good morning. How you doing?
I'm doing well, sir. Do you have business
This-
before the court?
I have a visit of 11 o'clock.
Okay.
This is Jarrett's last name McGoss.
What's your name?
Mr.
Terrence,
Goss
last name
was last,
Goss, yeah.
he was last week in the same position as Ms. Capers.
Was he reset? I don't think he was reset for today, was he?
Yes, I was reset at 11 o'clock today.
That must be it. Mr. Goss, good to meet you.
Sorry, Mr. McLeod, is there a way I could contact you later on for another, to talk about my case? I'm sorry to interrupt.
Call me at 770-891-4755.
891-4755,
Or text it.
and that was 770-891-4755.
Correct.
Okay, yes, sir. I will definitely give you contact, be in contact with you. Thank you so much, and you have a good holiday as well.
You too.
Okay, back to Mr. Goss. He was on last Thursday. Like I said, my odyssey is frozen. He was supposed to be reset to see Judge Williams again, so I strongly do not believe today is his court date.
It is not. I've been told that he was reset till December 1st.
Right, and I would love to accommodate him appearing, but like I said, my odyssey is frozen, and I vaguely remember the facts, but today is not his court date.
Okay.
And Judge Williams particularly wanted to see him.
Hey, can I say something?
Mr. Goss, would you do me a favor? Would you text me at 770-891-4755 so I have your contact information and we can talk all about this case?
Hold on. Let me get that number. You said 770?
Yes, 891-4755.
4755?
That's it.
Your name is?
McClain. I'll tell you my name when you text me. Just text me.
McClain MC?
Just text me. You got the number. Thank you. MCCLAIN, Michael McClain.
Okay, hold on.
Just text me and we'll talk all about this case and the date it's coming up on so that we can get on with today. And you have
okay.
You have a super
Thanksgiving. Hey, quick question. Is the warrant going to be removed? That's the whole point of calling, being on the Zoom today.
Yeah, that's the whole point of the conversation we're going to have in the future. Thank you.
Okay, sounds good. Thank you, Michael.
Thank you.
Yeah, I have a good Thanksgiving.
All right, eat some turkey.
All right, thank you.
Okay, so as soon as Ms. Lewis is ready, we'll go over the calendar.
You got everything.
Which position? Well, at this point, it'd have to be, we've got down released. If he's not released, then he's gonna have to be set onto the next calendar.
All right, can y'all hear me? Y'all ready to go? over
Yes,
now?
ma'am. We can hear you.
We start with the Adolf counter. Position 1 and 2 were complete. Let's take care of the Adolf. We're going to the regular counter now. Position number 1 was a plea. Position number 2 was a plea. Position number 3 was a plea. 4, defendant was arraigned, cases reset for trial further notice. Position number 5 was a plea. Position number 6, 7, 8, and 9 is going to be come back to the original judge for trial. Position number 10 was a plea. Position number 11, defendant was released, cases reset further notice. Position number 12, defendant was arraigned, cases reset for trial further notice. Position number 13, defendant was arraigned, cases reset for trial further notice. Position number 14, I have reset for SAP November 29th. Position number 15, defendant was arraigned, set further notice for trial, amended bond to $20,000 SOB to the jail that Mr. Ford will be getting to shortly. Position number 16 was a plea. Position number 17 was a plea. Position number 18 was a plea, extra time. Position number 19, defendant was arraigned, cases reset for the notice for trial. Position number 20 was a plea. Position 21 was a plea. Position 22 was a plea. Position 23 was a plea. Also 24 was a plea. 25 was a plea. 26, defendant was released in case of set for the notice. Position 27 was a non-class. Position 28 is a plea. Position 29 was a plea. Position number 30 is a plea. Position 31 non-class. Position number 32, defendant is waiving arraignment. We set for trial for the notice. I think I'm supposed to be seeing that for Mr. Finland. Position number 33 was a plea. Position 34 was a plea. Position 35 I have been set for SAP November 29th. Position 36, defendant was released and is set for the notice. Position 37, I see there's set for image valuation. That's going to be December the 8th. Does any problems with that for the meeting? Because y'all didn't put the date down here, so I sent it out to December 8th. Okay, no, so I guess it's gonna be good. Position number 38 is a plea. Position 39, the defendant was released, case is set for the notice. Position number 4, the defendant is still incarcerated at Fulton County Jail. I don't know why he was not brought out, but not released. Case is set for the next SAP November 29. Position 41 was a plea. Position 42
defendant was released, case was set for the notice. Position 23 was a plea. Position 44, defendant was arraigned, case was set for the notice for trial. Position 45 was a plea. Any questions?
No. Happy Thanksgiving, Miss Lewis and everyone.
Thank you, Mr. Walker.
Bye.
You sound so enthusiastic, Mr. Walker.
Just a few more days. Almost there.
Hang on. All right, I appreciate it, everyone. Thank you so much.
I know everybody's at the jail. You guys can, I don't know if you're gonna walk your paperwork down to me, Mr. Ford, Mr. McLean, Mr. Finley. Please make my day a nice day. That's all I ask. Thank you for all the dog process for all the ASG that sent them to me. I got them. Thank you very much.
You're welcome.
Yes, the state is always prepared.
Ooh.
I appreciate that, Ms. Key.
All right, y'all have a good one. Be safe.